This is the requirements and points of an ethical contract that I have identified as being logically and objectively required. This video is an update from the past video I made on October 16, 2024. This will no longer be available. A contract is a documented agreement between an offeror and offeree which contains all of the following points. 1. There must be valuable consideration. This is the reason for the contract's creation, to facilitate a trade of value. For something to be of value, it must be considered mutually beneficial by both parties. And what I'm doing now is I'm going to use a chatbot to assist me. I've done the hard work and it's going to help me out with the rest. So all I did is I fed it this information and then asked me to give 3 examples for point 1, and I'll be using this strategy for the rest of the video. It's important to understand how a contract works, what it's for, and why we actually want ethical contracts, because this world is built on a system of fraud. Whether it's incarnating into this world, the world as a whole, if it's the legal system, sovereignty, paying fines and tax, it is in your best interest to understand what an ethical contract is and its points therein. So here is valuable consideration in an employment contract. So the offerer would be a tech company. The offeree is a software engineer. So imagine you're an engineer and you're looking for a job, and this tech company has a job for you. So the valuable consideration is a salary of $100,000 per year, and you are going to trade your skills, time, and expertise. Here for a real estate purchase agreement, the offerer is a home seller, and they're selling a house at $300,000 and someone wants to buy it for $300,000 cash. Or it could be a whole lot of gold, or it could be 4 different cars. There has to be some kind of valuable consideration, something that is worth it to both parties. Freelance service agreement, a graphic designer, marketing agency. I think you understand the drift by this point. Offer and acceptance. There must be an offer of trade. It can't be presumed or assumed or guessed at. There needs to be an actual offer and an acceptance. An offer of trade of one type of value for another must be made and accepted. And then you get into next, it needs to be fully disclosed. So when you get into the birth certificate fraud, obviously there's been a big naughty there, because there wasn't informed consent with the offer and acceptance. Here, get this birth certificate and transfer your child into a legal person. It'll be good for you, we promise. I'm using Mistral here. It's called, can I see it up here? No, if I go there, see it's Mistral. I have a few options. I'm using the DuckDuckGo chatbot system, which apparently protects my privacy and anonymity better than other chatbots. It works for me so far. Always must use discernment. Give 2 examples for point 2. Are these any good? Okay. A landscaping company offers to maintain a client's garden for $200 per month. I have a friend who does this sort of work. Weekly mowing, trimming, and seasonal planting. Offer and acceptance. Yeah, and then you accept that. Rental agreement, offer, acceptance. Okay, it's very straightforward as well. So full disclosure, there must be transparency and clear terms and no ambiguity, equivocation, doublespeak, or deception. The offerer has a duty to ensure the offeree understands all the details. The terms must be as simple as possible. The offeree has a duty to fully disclose their capacity. Because how often do you find contracts where the terms are deliberately as complex as possible, so you don't read it, you can't understand it, you just click, oh, okay, all right, I want to use this app or download that software, and you just agree because it's just jargon. It's deliberately ambiguous and complicated. So looking at examples of a violation of full disclosure. Well, I mean, you could bring in banking and birth certificates and license and all that, but let's look at a few more everyday examples. A car salesperson says that the car is in good condition. Well, what's that mean? Good compared to what? To whom? Without specifying what it means. It's in good condition. The engine doesn't work, but the rest of the car's in good condition. So the buyer purchases the car realizing there's lots of problems. So there's ambiguity of language there. There should be no ambiguity. Equivocation. The agent describes the property as having a spacious backyard, when in reality the backyard is small and overgrown. Spacious to whom? A flea? Sure, it might be very spacious then, but not to a human. So it's vague language to mislead the buyer. That's why you should always inspect your properties before purchasing. Double speak. So it's saying that a software licensing agreement can say for personal use only, but inside all the jargon and complexity, personal use is extremely restrictive. It's a type of double speak. Deception. A contractor offers to renovate a kitchen. Well, I came across once a deception. When I was in Serbia, I parked my car in a zone where there was no signage, and I came back and my car had been towed by the council and I had to pay $100 to get it out of the compound. And I took photos and videos of the area and there was no information saying that you can't park there. That's more of a scam than an unethical contract. That was just a pure scam, and government's doing what governments do, but still, it was a deception. Well, it was more just a complete scam. It was a robbery, really. But this example is saying with a contractor offering to renovate a kitchen, there's substandard materials, and just full deception. This stuff's pretty easy. Lack of transparency, failure to ensure understanding. You can only do so much. If the person you're talking to is an idiot, the offeree, you can only help them understand to a certain degree. You can't understand for them. So you just must do your best to help the other party understand what they're getting themselves into, or what they're buying from you, what they're trading. Think about the perspective if we as beings decided to incarnate into this world and we were sold the idea of a happy, beautiful place to experience life. There obviously was not full disclosure on incarnating down into Earth, if theoretically that is true. Because if there was full disclosure, this place would be absolutely empty. There would be no one here. Who would volunteer to come to a place that is dominated by cruelty, which is primarily the experience of cruelty? No one would come here. So there obviously is not a full disclosure of coming down to Earth, of how painful the human body is, or any body that you inhabit, whether insect, animal, or human. They all seem quite painful. When a crocodile rips off a zebra's face, it doesn't look like it's having a good time. There obviously has not been a full disclosure here. And in this circumstance, the offeree has a duty to fully disclose their capacity. That really comes down to here with 10A and B about capacity. But it's still full disclosure, because you need to disclose your capacity, whether it's to repay the debt incurred by the contract or fulfill the duties and obligations inside the contract. You need to state clearly that you do have a capacity. So that links in with full disclosure and in 10A and B. Next, with equitable intentions, the offeror would sign the contract if in the offeree's position. So you would switch roles, essentially. It's the golden rule of equity, to treat others as you wish to be treated. The intentions on both sides should be honest and respectful. And we don't even need examples for that. Well, it is common sense, but how common is it actually? It's not common at all. It's rare sense. That's what it should be called. 5, amendments and dispute resolution. There should be an objectively moral and equitable process for resolving disputes and making amendments. Because even between two rational and objectively good people, there can be disputes and misunderstandings in contracts. Even if there is full disclosure, problems can arise, and that's okay. You just want to have a good system of making amendments and rectifying disputes. Though there's an asterisk here, because for some contracts it's not always available. Click wrap contracts. So, say if I'm selling a computer game and I'm selling it en masse, hundreds of thousands, millions of copies of a computer game, and I'm saying you're not allowed to cheat in multiplayer in this game, and you don't have the ability to make any amendments or solve any disputes, because that is my policy. You play this computer game, You're not allowed to cheat. Then if we find you cheating, we get to ban your account. There's no amendments, there's no dispute resolution. You can't do anything about it. So it depends on the type of contracts that you're signing. A click wrap contract would be with Facebook or downloading software where it's just, here's the terms, you click agree or you don't use the product. Sometimes it's understandable, sometimes it's a pain and it's wrong because you have no other choice. Say for instance, using banking apps. They all use click wrap contracts and you've got no choice because you need to bank. It's an evil, terrible system and you can't get around it, unfortunately. But hey, welcome to Earth, that's the point. Accountability. Parties must take responsibility for their commitments, breaches, and fraud. They must agree that violations of the terms can be enforceable by third parties in the pursuit of justice. So you need to be held accountable, whoever the contract is between. On either side, if you agree to repay a debt for a car or a home or whatever it is, you are saying, I am responsible for this debt. For instance, if you get injured and you lose your job and you can't afford to repay the contract, well, that's when you need to have some kind of amendment and dispute resolution, because you would have repaid the debt for that car, but now you can't work, you can't afford it, etc. That's why you need to have this, because there needs to be equitable intentions, because if the offerer was on the other side, they can understand, oh, you're in an accident, you can't walk now, you can't work, you can't afford to pay off this car loan. Okay. Well, we need to have some process for what we do in situations like that. 7, opening and closing conditions. So it's not just a termination clause, but it's also opening. When does the contract begin? How can we close or terminate the contract? If it doesn't have opening and closing conditions, it's an unethical contract. That's like with this social contract nonsensical bullshit that the mainstream governments like to use. Oh, you've agreed to a social contract to living in a society and you can't opt out. You are hereby bound to subvert yourself to our rules, policies and legislation because a whole bunch of other mindless zombies voted for this dictator without any intelligence to rule over you and to make unethical, subjective, biased, cruel regulations. So, no. You can't do that. An ethical contract is going to Jet's Gym and you sign on the dotted line and it says this contract will begin today and it will renew every month until you decide to cancel. When you cancel, it'll end in the following month. So it needs to have opening and closing conditions. Access, number 8. So obviously the police and the courts never give you access to the copy of the contract, which makes you subordinate to their legislation. They can't provide that document. That's why negative averment, as I've explained in prior videos, is such a useful tool for combating the legal system. Magistrate, I'm not aware of any evidence which says I've signed a copy of this contract submitting myself to be obligated by this legislation. If you have this copy, please provide it. If they did, they must provide it. Access. Even if it's something simple, you have an employee working for you as an employer and they ask to see the contract or get a copy because they lost theirs. Well, you must provide that because that's the right thing to do. If you were in that position, you would want a copy. A proper contract needs to be documented, as stated in the original explanation, short definition of what a contract is. It's documented. You can have verbal contracts, but they just don't have as much weight. It's not a proper contract. It must be documented because human memory is absolutely awful by design. It's much easier to control a population who can't even remember what they ate for breakfast yesterday than it is a population with photographic memory. Think about that one. If you can remember to, you'll probably forget this in 15 minutes. So sad. Mutual consent. Obviously, there needs to be consent for both parties without coercion or deception. Don't need to explain that one. 10. Capacity. Both parties must have the capacity to enter the contract. So you can't be a child, underage, you can't be drunk or drugged or hypnotized, mind controlled of some sort, retarded, extremely ignorant, experiencing emotional hardship, unauthorized. So some of these are simple. So here's an example of extreme ignorance in a contract. So a timeshare company is selling a timeshare property to an elderly individual who, it could be anyone who just doesn't really understand it. And those systems are extremely complex, full of jargon, ambiguity, doublespeak, all sorts of deliberate complexity and deception. And there's an upfront fee, annual maintenance fees, possibilities for increasing fees, long-term commitments. Especially when it's that complex, to someone who's a layman, it can be questionable whether this kind of agreement, even if it was voluntary, is ethical. So if the elderly individual was having trouble exiting the contract or amending or raising a dispute, then it could go to a court of competent, objective jurisdiction to be mediated. So there may be mitigating circumstances if someone who was experiencing emotional hardship enters into a contract, like a breakup or a family member's death or some kind of disability. That is why I have here in full disclosure that the offeree has a duty to fully disclose their capacity. So the elderly individual should admit in the beginning, hey, I've got no idea about timeshares. You as the offerer, you need to do your best to fully explain these complicated terms and conditions in simple terms so the elderly individual can understand. Or if you had been experiencing emotional hardship, then you need to disclose that, whether you're buying a car or entering into some contract. Because then the sales representative or the offerer can say, maybe it's not the best time for you to be entering into this contract because you have just experienced this emotional situation. Maybe it's best you wait a week, a month, and then you come back. But then if the offeree insists, no, it's okay, well, that would therefore create more solidity to the contract because they have disclosed their capacity, but they have reassured the offerer that it won't interfere with their capacity to enter into a contract. These things need to be taken into consideration. There needs to be a proper objective process so then people don't get taken advantage of or get themselves into situations they shouldn't. Unauthorized, so someone who is working for a company, say you are the employer of a big fitness franchise and you have a staff member and they make a mistake and they believe they have the authority to enter your corporation, your company, your fitness franchise into a contract, but the agent of your business acted in a way where they weren't authorized. They made a mistake. They had authority in one scope, but not another. So there must be correct authorization to enter into a contract. Otherwise it can null and void or vitiate a contract's tightness. Capacity B. Both parties must have the capacity to fulfill the contract. If it's a job, you must have the appropriate knowledge. If it's a role to be a surgeon, well, you have to have the appropriate knowledge to be able to perform that role. Skill, funds, materials, you need to be able to pay off the debt. If you're that kitchen renovator, you need to be able to access the materials. You don't enter into a contract and then say, oh, I haven't got any materials, it's going to take another 6 months to find them. Well, no, then the offerer who was looking for a kitchen renovator could have the right then to sue you because you're meant to have the materials for that kitchen renovation and then you don't. You have to have capacity on both sides for a lot of things to properly enter into the contract. So lawful. The contract cannot be in violation of objective morality or objective law, even if both parties agree, if I don't repay this car loan, then you have the right to cut off my hand. Well, that's not going to be enforceable. There won't be any accountability for that kind of enforcement because it is unlawful. It's a violation of objective morality and objective law, even though both parties agreed to it. An objective system of law is not going to enforce cruel and unusual punishment. That is barbaric. So even though both parties may agree to it, it needs to be in the confines of morality and its subsequent objective law, which is, of course, as I've explained in prior videos, derived from objective morality. And where does that come from? Objective reality. And this stuff can be logically discovered. 12, identity and ultimate individual liability. So the contract ultimately needs to be between two people. Sure, you can contract with a corporation, but there needs to be an individual, a named individual with ultimate liability on both sides. There are lots of reasons for this. That's very important and very uncommon today because it allows criminals to get away with murder and criminal activities of all sorts. If you want to know more about this, what I do is I just go to ChatGPT, any chatbot, and I'd say, challenge the pros and cons of point 12. And I'd present it with an idea I think is valid, and I'd say, challenge it. Tell me what's right with this, tell me what's wrong with it. And then you're able to discover, oh, okay, you actually do want this, because any argument against it is invalid, it's subjective, it's biased, it's just not good enough. So pros and cons, and you can do a bit of legwork yourself and figure that out. So that's the points I have of a valid contract, which may update in the future. That's why I don't have it as 9 points or 14 points, 12 points. It's just the requirements and points because this is subject to change as I learn. So in some instances, a contract may require a meeting of the minds and the ability to negotiate, but not all contracts require this. So you'd want to check on the context of what you are entering into. Confidentiality. In some contracts, sensitive information must be protected. You can have secession clauses, so stipulations that if a named individual leaves, that's linking in with identity and ultimate individual liability, the contract must be renegotiated with the new responsible parties. Say you enter into a contract with Pepper Finance for getting a new Mustang. I've actually done that in the past. And the accountable person is, let's say, Gary. And Gary's working at the corporation and he has accountability, responsibility, culpability if anything goes wrong, and he decides to leave that company. Well, there needs to now be a new named individual with liability. So a new party needs to come along and the contract, well, it can be renegotiated, or you have some kind of secession clause for what happens in that situation if the named individual of that company is replaced or changes. Indemnification clauses, specificity of circumstances for liability, so that links in with here and here. And we covered click wrap contracts already. So I hope you found this information valuable and you can apply it to many different contexts that you see fit, so you do the right thing when you are offering someone to enter into a contract or when you are entering into a contract. You can know what to look for, and this lines up with fraud. So if you enter into a contract mistakenly and you suspect fraud, you can know what all the requirements of an ethical contract are and all the requirements of fraud are. So if you ever do need to go into a court-like setting, you'll have more power and knowledge to defend yourself. So keep that in mind for all contexts, this world and the next. Hope you enjoyed the video. Bye-bye.